Okay, Harshit, so let's proceed ahead with your brief introduction.
अच्छा, हाँ, thank you so much, sir, for providing me this opportunity. Myself Harshit Upadhyay, and I belong to Ayodhya district in Uttar Pradesh. Sir, I have completed my education in 2015. In 2015, I have joined the University of Lucknow for BA LLB honors, which I have completed in 2021, and I joined the University of Delhi thereafter for my post graduations, and which I have recently completed in 2023. Sir, during my law course, I was also engaged in various co-curricular activities like internships, moot courts. I have around 4 publications in my name. Sir, here I would like to mention one thing. In 2015, I was selected by British Council under the British Council Student Exchange Program to visit the United Kingdom to study the So, sir, these are my qualifications and other activities.
Harshit, you are working somewhere?
Sir, no, sir. I have just recently completed my LLM in 2023.
You have done LLM.
So I am not working now.
You have done your LLM?
Yes, sir.
तो LLM क्यों किया आपने?
Yes, sir. I have done even when I have completed my LLB. LLB, then, sir, I just wanted to continue my studies along with the preparation with other exam like PSUs, because sir, I think that you cannot prepare anything by just by sitting at home. If you are engaged in some institution, it will surely enhance your knowledge ability and it will give a exposure. And the second thing, sir, I got admission in University of Delhi. So I think that I must study in this university to enhance my knowledge. As I have completed my LLB from a conventional institution in University of Lucknow. So by studying in University of Delhi, even for the post graduation course, sir, has given me a extra advantage and exposure in legal field.
Okay, Harshit, now instead of pursuing law in normal judicial system, you're preferring corporate law and corporates. What is the reason you want to join public sector?
Sir, from very beginning, from the beginning of my law course, sir, I was clear in my mind that after LLB, either I will join the litigation. I think that by joining the PSUs or litigation, you can use or utilize your knowledge and skill in more efficient manner. It unlike the judiciary, especially in subordinate judiciary. Sir, I think in subordinate judiciary, you does not have the enough space to utilize your legal thinking or knowledge because there are multiple limitation or foundation. You have to follow the set pattern of rules and practices. Although in High Court and Supreme Court you have certain judicial discretion, but in subordinate courts you are not allowed to use your knowledge, experience, or judicial mind in the effective manner. So I think by joining the PSUs, I can utilize my knowledge and legal knowledge and experience in more effective manner. That's why I was never inclined towards the judiciary. It was never on my radar, sir.
What is the difference between writ and PAL?
Sir, if we talk about the writ and PIL, so sir, PIL is basically a proceeding which is for the public related matters, where any person can file the PIL to represent the public at large for any matter which is for the benefit of public at large. But writ is basically a proceeding which a person can file for himself. There are certain writs which can be filed for the other for the by the other person also, where the rule of locus standi has been relaxed, like habeas corpus. But most of the writs can be filed by the aggrieved person himself. But the PIL can be filed by any public spirited citizen. Writ are of 5 kinds: mandamus, habeas corpus, certiorari, prohibition, and quo warranto.
हर्षित ये बताइए रिट ज्यूरिसडिक्शन सुप्रीम कोर्ट हाई कोर्ट को कौन से आर्टिकल में मिला है?
सर, सुप्रीम कोर्ट को आर्टिकल 32 में रिट ज्यूरिसडिक्शन मिला है और हाई कोर्ट को 226 में।
अभी ये जो सुप्रीम कोर्ट में केस चला अबाउट चंडीगढ़ काउंसलर वो जो हुआ था केस, वो क्या केस था?
सर चंडीगढ़ में एक्चुअली चंडीगढ़ में मेयर्स इलेक्शन हुए थे
हम्म।
एंड वेयर देयर वर टू साइड्स, वन इज लेड बाय द बीजेपी एंड द सेकंड वन वाज द कोलिशन बिटवीन
ये
द
मेरे को
आम।
कंस्टिट्यूशनल एंगल बताओ बस इसका, टेल
ओके
मी द
ओके
कंस्टिट्यूशनल एंगल।
हाँ सर, तो सर देयर वर सम फ्रॉड इन द कॉन्स्टिट्यूशन ऑन इन द इलेक्शन बाय द रिटर्निंग ऑफिसर। तो सर
हम्म।
सुप्रीम कोर्ट ने इसको डिसाइड किया था। इसमें सुप्रीम कोर्ट ने मेनली आर्टिकल 142 ऑफ द कॉन्स्टिट्यूशन यूज करके अपना जजमेंट दिया था, और इन्होंने
हम्म।
न सिर्फ उस इलेक्शन को स्टेप डाउन किया था, बल्कि उन्होंने जो आम आदमी पार्टी का कैंडिडेट था, मेयर था, उसको उन्होंने विनर डिक्लेयर किया था टू कंप्लीट द जस्टिस। बिकॉज आर्टिकल 142 जो होता है वो पावर करता है कोर्ट को टू पास एनी ऑर्डर, डिक्री और रिट विच इज नेसेसरी टू कंप्लीट द जस्टिस, even if that matter is not a cause of issue in the suit. So the court can pass the order, and by using this power, the court has declared the winner to the Aam Aadmi Party candidate.
देखिए, इलेक्शन कमीशन ऑफ इंडिया जो है वो कुछ इलेक्शंस करवाता है।
Yes,
ये जो
sir.
म्यूनिसिपैलिटीज और इसके इलेक्शंस होते हैं, ये कौन बॉडी करवाता है?
सर म्यूनिसपालिटी सर इलेक्शन इलेक्शन कमीशन इंडिया सर, जो इलेक्शन कमीशन ऑफ इंडिया है, इसके अलावा सर कुछ रीजनल इलेक्शन कमिश्नर कमीशन को भी अपॉइंट करने का प्रावधान या प्रोविजन हमारे कॉन्स्टिट्यूशन में है। तो
हम्म।
सर जो रीजनल इलेक्शंस होते हैं
हम्म।
वो जो म्यूनिसपालिटीज इलेक्शन होते हैं वो स्टेट इलेक्शन कमीशन कंडक्ट करवाती है।
लेकिन स्टेट इलेक्शन कमीशन चंडीगढ़ स्टेट तो है नहीं।
हाँ तो सर इट वाज कंडक्टेड बाय अंडर द सुपरविजन ऑफ द सेंट्रल गवर्नमेंट।
सेंट्रल गवर्नमेंट और इलेक्शन कमीशन ऑफ इंडिया।
सॉरी सॉरी सर, इलेक्शन कमीशन ऑफ इंडिया।
इलेक्शन
सर
कमीशन के अंडर हुआ था ये?
सर सर आई एम नॉट प्रीटी श्योर अबाउट दिस, आई विल
अच्छा,
लुक आफ्टर
रिप्रेजेंटेशन
दिस।
ऑफ पीपल एक्ट के बारे में क्या जानते हैं आप? कौन कौन से ईयर में बना था ये? क्या है रिप्रेजेंटेशन ऑफ पीपल एक्ट?
Sir, Representation of People Act is basically a act to deal with the conduct of election, to deal and to regulate the election process of the country. Representation of People Act was enacted, sir, if I am not wrong, in 1951. And sir, it basically deals with the like the qualifications of the candidates and the disqualification of the candidate. What will be the bribery and what will be the election fraud? So it deals with the election related matters and regulate the election of the country.
हर्षित, मर्जर और एक्विजिशन के बारे में क्या जानते हैं आप?
Sir, merger.
जो
Sir,
कॉर्पोरेट
merger
में
is
मर्जर एंड
sir.
एक्विजिशन होता है।
हाँ, yes, sir. The merger is basically the process where where the small portion of right is merged with the uh, bigger for the rights. So, and acquisition is where a company acquired the another company. Acquisition is of process. Sir, sir, I don't.
अच्छा, आपको हर्षित क्यों
Sir,
लगता है दैट यू शुड बी सिलेक्टेड बाय पावर ग्रिड?
so, sir, I
व्हाई यू?
think that the sir, the qualification and the qualification and the sir, experience which is required by the PSU. I think I hold all those qualifications and all those skills. And moreover, sir, it was I was very clear, as I told earlier, that sir, I was very clear from my mind that I will join the PSU. So if I get selected in the power grid, so it will be like my dream coming true, sir. I will do my best to do justice whatever role, whatever assignment is given to me, and I will surely work with my 100% ability for the greatest common advantage of this corporation, and I will perform my task with utmost hard work, commitment. And I don't think, sir, any public sector undertaking or any corporation requires something else from its employees other than honesty, commitment, and hard work. Sir, I have all these things.
ओके, निशान जी।
Yes, Harshit.
Yes, sir. Hello, sir.
Okay. Tell me the various provisions of the Electricity Act 2003.
Sorry, sir. I am not much knowledge about the Electricity Act. I have been gone through it yet with this act.
Uh, the basic provisions of Indian Contract Act.
Sir, Indian Contract Act basically an act which was enacted in 1872 to deal with and to regulate the contractual relationships. So, if we talk about first of all, if we talk about the contract, it has been defined under Section 2H of the Indian Contract Act. We provide that all agreement enforceable by law is a contract. Now, agreement is the consideration or set of consideration and forming the consideration for each other. Sir, so not agreements are enforceable by law. It is discussed in Section 10. Every agreement which is made with the free consent of the parties competent to contract and for a lawful consideration with a lawful object and not expressly declared to be void is agreement which is enforceable by contract. Now, sir, if we talk about the other provision, so Section 11 deals with the like the parties who are competent to contract. Section 12 provides that the who will be of sound mind for the purpose of contracting, and section 14 to section 19 deals with the free what will be the free consent, like if it is not affected by undue influence, coercion, etc. Then such section 20 to 22 deals with the mistakes, and section 25, sir, deals with the aspect of consideration, that why consideration is important, a privity of contract, etc. And sir, 26 to section 20 section 30 deals with the other requirements of the contract, like the contract should not be in restraint to the trade, it should not be in restraint to the marriage and legal proceeding, and it should not be uncertain. Then, sir, we have the further provisions of wagering contract, contingent contract from 30 to 36, and sir, further in section 56 talks about the contract which are impossible to perform, doctrine of frustration. Section 37 to section 50 talks about the performance of the contract. Section 60 to 64 talks about the how the contract is discharged by rescission, novation, alteration. Sir, section 68 to 72 deals with the quasi contract. Sir, these are the problems. Then, sir, from section 124 to 239 deal with the specific kind of contract, like guarantee, indemnity, etc.
Okay. Okay. Tell me the what is Indian Electricity Grid Code?
Indian electricity grid course. Sorry, sir. Sir, I am not much aware with these electricity
Okay,
and power act.
electricity sector. Okay.
Sir, I will look. I will look on these act, but now at this point of time, I am not much aware.
Okay. As we know that there are mainly two method of dispute settlement, that is the litigation and the arbitration
Yes,
under
sir.
the Arbitration Act 1996. Okay.
Yes, sir.
What you think ki where we can use the litigation method and where the arbitration method can be used, and which method is better to resolve the conflicts?
Yes, sir. Sir, sir, basically the arbitration method is the part of ADR, Alternative Dispute Resolution, sir, which has been given effect in 1999 by inserting the provision in Code of Civil Procedure in Order 10 Rule 1A and Section 89. Sir, I think arbitration is the alternative process which gives a more convenient and easy way to parties where they can settle their dispute in with some little amount of time and with little hard work. Like here, I would like to mention certain provisions of the Arbitration Act, which shows that how the Arbitration Act more convenient than the regular proceeding. Like in Arbitration Act, the parties can settle their own language of proceeding. The parties can appoint their own arbitrators. The arbitration proceeding is not bound by the procedure provided in the CPC or Evidence Act. So these things says that the arbitration is more convenient. But being the convenient doesn't mean it has any effect on its enforceability. Like arbitration award is binding on the party in the same manner as the judicial proceeding. The arbitral court can also enforce the arbitral award. It the appeal can be filed under the Arbitration Act. So I think that under the Arbitration Act, the proceedings are more convenient in one hand, and in other hand, it has the same effect and it has more effective in the same manner as the judicial proceeding. So I think, sir, arbitration proceeding is a suitable way to settle the dispute.
Okay. As we know, the Environment Protection Act 1986 is applicable in all the industries. Okay, which provisions the power grid has to follow from the Environment Protection Act 1986?
Sir, I can't, sir, I can't recall the particular sections, but there are certain principles which are provided under the Environment Protection Act, like polluter pays principle, precautionary principle, and so these principles are required to be followed by every industry and every corporation engaged in the work which may cause the environmental degradation or environmental pollution. So I think the power grid is also required to follow these basic principles.
Okay. Next, the Right to Information Act 2005, right?
Yes,
Is it applicable on Power Grid, or which are the companies to whom the Right to Information Act is applicable, and which are the companies on which it is not applicable?
sir. First of all, right to information act is perfectly applicable upon the power grid because the power grid is the public sector undertaking, and it also comes within the definition of state under Article 12 of the Constitution of India. So, Right to Information Act is also applicable on the power grid. So, Right to Information Act are basically applicable on those companies, on those organizations which are work under the supervision and control of the government or state, or which are funded or receive the funds by the government. So, Power Grid also comes within this ambit of criteria. So that's why RTI Power Grid also comes within the ambit of RTI.
Okay. What are the rights and rights of Board of Directors under the Companies Act 2013?
Sir, sir, I am not much aware.
Okay.
Sir, I will look now.
And what is the difference between Memorandum of Association and Article of Association, MOA
Yes,
and
sir.
AOA?
Yes, sir. Sir, memorandum of association, article of association are basically like the set of rules and regulations which are to be followed by the companies in their in their functioning while carrying out the business. Sir, memorandum of association is the bigger aspect which is to be prepared by the company before its incorporation. It deals with the matters like what will be the object of the company, what will be the share capital of the company, and other matters which are necessary for the incorporation of the company. Whereas article of association deals with the inner functioning of the company. So memorandum of arbitration is basically the genesis, and the article of association is basically the species, which deals with the inner activities of the companies, whereas memorandum of association deals with all the fundamentals of the companies.
Okay. According to the Factories Act 1948, right, what are the provisions regarding the working hours of the workers and the overtime?
Sir, I can't recall the specific section, but sir, what I know that according to the factories, sir, I may be wrong on this, but sir, I can recall if any employees in the factory, if any worker in the factory is required to work beyond his working hour, then he will be required to paid the double of his regular amount of payment as a overtime allowance.
Yes. But how many hours we can put the worker on duty in a particular day or in a week?
Sir, I think in a sir, 10 hours. Sir, sorry, sir, I can't
Okay, okay, no
recall.
problem. Okay, according to the EPF Act 1952, Implied Provident Fund Act, right? What is the contribution of by the employer and the employee and employer to the EPF account?
Sorry, sir, I I don't I don't.
Okay, and what what is the minimum maximum salary uh, for ESI, like employee state insurance facility, to avail the employee insurance facility?
Sorry, sir. Sir,
No.
I can't answer
Okay.
this question.
Okay. My last question is, what is the procedure for the incorporation of company?
Sir, procedure, sir. First, first of all, sir, there should be an idea for incorporating the companies. Then there should be appointment of a promoter. A promoter will be appointed. And a prospectus will be released by the company. And to call for the investors. To call for the investors, then after calling them for the investor, the company will provide for its registration under section 10. Sorry, sir, section 8 of the Companies Act 2013. And after the registration of the company, and at the time of registration, the memorandum of association and article of association of the company shall be filed. And there are certain things which have to be mentioned in the memorandum of association, like what will be the object of the company, and what will be the nature of the company, whether it will be a limited company or limited by share or limited by equity, and what will be the registration office, where will be the registering office of the company, and what will be the name of the company. Then certain basic information has to be provided to the registering officer at the time of applying for registration. After the registration of the company will be get corporated, and it will start functioning accordingly.
And as you mentioned that the company will be incorporated after the registration of the company, right? Then how the company will appoint the promoters and call the investors? Because at that time company is not in existence.
Sir, sorry, sir. I have to go
Okay.
through, sir. I
Yes. Okay. Actually, these are the pre-incorporation activities done by the promoters only, because company is not in the existence, and the
Yes,
idea
sir.
generation in the mind of promoter, they will decide each and everything. These are the pre-incorporation activities. Even the
Thank you.
expenses bear during this process are our preliminary expenses, because the accounting books are not started yet of the company, right? And that's why we
Okay, sir.
included in the assert side of under that preliminary expenses, and we set off these expenses under the this security premium reserve accounts if we sell our shares at a higher rate of the face value.
Okay.
Okay, Harshit, I will conclude here, and according to my observation, you are good enough. You have done your LLB, LLM, and you got a chance for the foreign visit and get some specialized knowledge. But I will suggest to you to go for these acts, especially the Electricity Act 2003. That will be very helpful to you in the interview. And
Yes, sir. I
this
will.
and Companies Act 2013 and Contract Act. Actually, all these acts which I touched today, all are very important. Factory Act 1948 is very important, because maximum we can put a worker for 8 working hours, with the after 5 years we have to give minimum half an hour, means free time for their lunch or the rest. Means that's why a
Okay.
worker can be remain in the factory for 8.5 hours, with the half hour free time and 8 hour working time. And if we want to get some overtime from the worker, then maximum 2 hours a day, maximum 2 hours. Then 10 hours working and half an hour rest time will be there. And week during a week we can put a worker on overtime maximum for 3 days, means 6 hours only.
Okay, sir.
Because these are the basic concepts, and which you have to deal if you are selected here. And so basic knowledge about the Electricity Act, Factories Act, various provisions of safety, workers, women's, child, adolescent, all these are required. So I will suggest you to go through these act and at least basic knowledge should be there about these acts, right? And
Okay.
yes, Dr. Vajender, your feedback.
Okay, Harshit. So, revise these technical terms of your law, right? Corporate law, whatever is requirement, why Power Grid, why you should be in Power Grid, what Power Grid does. Go to the website and roles and responsibility of legal officer in Power Grid. Please go for those things, right?
Okay, sir.
Got it, Harshit? And
Yes, sir.
yeah, and you should not criticize legal system. I mean, I asked you a question, why not regular legal system? Why corporate? Then you were criticizing legal system. Don't do that. Just focus on corporate. I want to go for it for this reason, but don't criticize. Don't say this does not happen there, this is not there. Don't do that. That is attitudinal issue. Don't do that. That is number one. Number two, know more about corporate law, right?
Okay, sir.
और जो करंट इश्यूज है वो थोड़े से रिवाइज करके रखना.